Assalamualaikum warahmatullahi wabarakatuh. So this is our part 4, or actually this is a final part for the topic trespass to person. So in the previous parts, okay, part 1, 2 and 3, we have covered assault, battery, and then followed by part 3, which is false imprisonment. So now it's part 4, the final part. Okay, actually this is a subtopic, okay, under for the topic trespass to person. So it is meant to cover defenses. Okay, here. So the title is defenses of trespass to person. So meaning that here, this defenses is specifically relevant for trespass to person. So we have at least 5 here, okay, to be discussed. So it covers consent, okay, and then lawful arrest, okay, reasonable condition, self-private defense, and necessity. So all these defenses actually are relevant, okay, for the action of trespass to person. Doesn't matter whether it is assault, battery, or even forced imprisonment. Okay, we go on by one. So we'll start with consent here. Okay, all right. So consent, it will be relevant, okay, for the adult, okay, who does not consent. Or maybe what if the consent is given by a child or by a mentally unsound person here. Okay, all right. So we have the issue here was discussed in the case of F and West Berkshire, okay, Berkshire Health Authority, okay, the keywords here is the best interest, okay, for the patient, okay, doctor perform operation on patient incapable of giving consent, because in some situations, for example, urgent situation, emergency, so the patient can't really, is not able to give the doctor consent in order to proceed with the treatment. Okay, let's go to the facts of the case here. Who was F here? So actually, F was a 36-year-old woman, okay, who had the mental age of a minor. So she's an adult, but the mental is of a minor. Okay, so her mother sought a declaration from the court, okay, to the effects that it will be lawful to sterilize her daughter, okay, who live permanently at a mental hospital, even though she is unable to consent to the operation due to her mental age. So basically, the mother, okay, was doing that for the best interest of the daughter, maybe to prevent the daughter from being pregnant, because the daughter couldn't really take care, okay, of her own self here. Okay, all right. So the mother was asking for a court declaration, okay, legal declaration, for the daughter to be sterilized, okay, for her best interest. Okay, another case is Aradel, okay, and Hashtrust and Blunt. So this is 1993 case here. It involved a patient, okay, in a condition of persistent vegetative state. I mean, lying down and then vegetative, all right? And then the issue is pertaining to to end the treatment, okay, in the absence of informed consent here. Okay, let's have a look. Okay, all right. So Glenn was injured. He was injured in the Hillsborough disaster. When we discussed nervous shock, all right, we discussed thoroughly the case of Hillsborough, okay, disaster. So he was one of the victims actually. He was injured, okay, when he was 17.5 years old. And after the incident, okay, the disaster, he was left in a persistent vegetative state. It's like this, okay, lying down, unable to do anything here, all right? So he remained in this vegetative state, okay, for over 2 years, okay, with no sign of improvement. So no, I mean, it's like no hope, okay, to become better, okay, to improve, whilst being kept alive by life support machines. So basically, he was totally dependent on life support machine. And Glenn, okay, could breathe by himself, okay, but required feeding via a tube and receive full care. So the only things that he could do is breathing, okay, but still he was on a life support machine. the doctors that were treating Bland, okay, were granted approval to remove the tube that was feeding him after 2 years here, all right? And then this decision was then appealed to the House of Lords by the solicitor acting on Bland's behalf. Meaning that here, the solicitor, okay, whoever representing him, was not agreeable, okay, to the doctor's decision. Okay, I mean, doctor asked for approval to remove the tube, the feeding tube here. All right, so what's the issue in this case here? Okay, the issue was that, okay, a patient that was in a persistent vegetative state, okay, like Bland here, cannot withhold or offer consent for treatment, obviously. Okay, so this requires the doctor to act in the best interest of the patient. So who can act for him? The doctor, okay, who have been taking care of Bland here, okay, the patient. So whether the continuation of Bland being on life support was in his best interest, okay, if he could make decision for his own life here, what could be, okay, what would be for him, the best interest for him. So the court held that on the basis that there was no potential for improvement, okay, the treatment Bland was receiving was deemed not to be in his best interest. Okay, so because of that, it is not lawful to cause or accelerate death. I mean, the approval was somehow legitimate, okay, legal in the eyes of law. Okay, the approval given to the doctor. Why? Because that's the best interest for the patient. So that's the case of Airedale National Health Service Trust and Bland, 1993. Okay, now let's move to federal constitution. In the earlier part of our discussion, okay, I mentioned about Article 5, which guarantees, okay, personal liberty, okay, to everyone, okay, to all citizens of Malaysia. So we have at least 3 clauses, okay, which are relevant to the topic here. For example, Article 5, Clause 2, no person shall be deprived of his personal liberty save in accordance with the law. And then clause 3, okay, if arrested, okay, the person, okay, must be informed of the grounds of arrest. So that's the right, okay, guaranteed by the federal constitution. And then article 5, clause 4 here, okay, actually we have to cross-refer, okay, to section 28 and 117 of CPC, okay, Criminal Procedural Code. Okay, this is basically the actual provision, okay, that I took it from federal constitution here. All right, it talk about liberty of the person. So we are done with consent. Now we go to the second defense here, which is lawful arrest. Okay, so what is lawful arrest? Okay, lawful arrest, it means, okay, an arrest made lawfully by whoever given authority. So of course, it is not a false imprisonment. See, meaning that here, especially if the plaintiff was arrested with a valid warrant of arrest. So in that situation, plaintiff can't really claim that he was he cannot really sue, okay, the police or whoever arrested him, okay, for false imprisonment or even for assault or battery here. All right, provided there's a valid warrant of arrest, okay, in most of the situation. So we need to cross-refer to CPC, Criminal Procedural Code, all right, which provides for arrest without warrant in certain situations. Mean that here normally we will require warrant, but in some exceptional situation, okay, there could be cases, all right, for arrest without warrant. Okay, all right, so what's the meaning of the word arrest? Okay, and what's the connection with the word restraint here? Okay, arrest means the seizure or contact with the body of an individual with an intention of restraining him. So that's the connection. I mean, there must be seizure or contact, okay, physical contact, in order to make an arrest. All right. So what the intention? To restrain him. All right, so that he cannot move or he can't really escape. All right. And powers of arrest here is not absolute. It has to be done according to Article 5, Clause 3 of the Federal Constitution. Okay, when a person is arrested, so he has the right, he shall be informed as soon as may be of the grounds of his arrest. He must be informed. Okay? He has the right to know, okay, and be allowed to consult and be defended by a legal practitioner of his choice. So we have many cases here. All right, this is some of the cases. For example, Abdul Malik bin Hussein and Burhan bin Haji Daud. Okay, Burhan bin Haji Daud and Abdul Malik bin Hussein. All right, so this is appeal. All right, this is the trial court level. So basically, these two cases, all right, these cases, okay, it is pertaining to the arrest under our former act, okay, ISA. Now it has been abolished and replaced, okay, with the similar act. Internal Security Act 1960, or we call it as ISA. Okay, we have another case which is Kwan Kwai Choi and AK Zaidi bin Matali, K 1993. Also, it involved police here. So, defendant, who was defendant? He was an inspector of police. So, he arrested the plaintiff under a warrant of arrest, and he brought her, okay, to the police station and locked her up. And the police did not bring her to the court that day. Okay, so because of that, the plaintiff, okay, sued the police inspector, and she claimed for damages for false imprisonment because of the delay here. Right, the police did not bring her to the court on the similar day. Okay, all right. So the court held that under Section 47 of CPC, okay, the police officer who executes a warrant of arrest, okay, shall, without unnecessary delay, so that's the emphasis of the word, okay, unnecessary delay, bring the person arrested before the court. So it's the duty, legal duty imposed on the police to bring the court, right, arrested person, to bring the person to before the court, all right. So as far as the case was concerned, the court found that there was unnecessary delay, and therefore, yes, the plaintiff was falsely imprisoned as far as the case was concerned. So plaintiff won the case. Okay, for the cases in which, okay, in what situation arrest without warrant is allowed? Because normally arrest would require warrant, okay, then it becomes lawful arrest. But in some situation, even arrest without warrant is considered as lawful and it is allowed by law. Okay, we have few situations here, a few provision. For example, Section 23, okay, CPC, it talk about arrest by police or even by penghulu, okay? Or Section 27, it talk about arrest made by private citizens, okay? And then for Section 28, also CPC, it talk about duty of the arrestor, what the arrestor has to do, okay? And then the last one is Section 117 CPC. It talk about duration of the arrest, okay, and then the power given to the magistrate to proceed with remand order. Okay, we are going to discuss one by one all the relevant sections just now. Okay, for example, Section 23 CPC, it gives the power to police or penghulu to do to effect an arrest without warrant. Okay, for what kind of cases? Okay, only for seizable offense. Okay, if the offense is non-seizable, then police or penghulu cannot do the arrest without warrant. Okay, what is seizable offense here? So under the penal code, example of seizable offense, it include, okay, murder, all the serious offenses, okay, murder, possession of offensive weapon, okay, wrongfully confining a person with intent to extort his property, okay, obstructing a public servant, okay, assault, all right. Dishonestly receiving stolen property. This is an example of seizable offenses under the penal code. So if the offenses involved are all this, okay, so police or penghulu are given the authority, the power to do the arrest without warrant. Okay, no need to apply. I mean to go and ask for a warrant. Okay, but then there's certain conditions attached to the arrest without warrant by police or penghulu here. Okay, there must be reasonable complaint, okay, or credible information has been received by this police or penghulu, and there also exists reasonable suspicion. So who has to prove all the elements here? Okay, is on the part of the arrestor. Who's the arrestor? Police or penghulu must prove to the court, okay, they did the arrest, okay, because of reasonable complaint or they receive some credible information, okay, and also there exists reasonable suspicion on their part here. Okay, and then this is further discussion on reasonable complaint or credible information. What amounts to reasonable complaint or what amounts to credible information here? So basically, a complaint, right, is an allegation made orally, okay, or in writing. So both ways are accepted to a magistrate, okay, with a view to his taking action under secrecy that some person has committed or is guilty of an offense, okay. Or what is credible information? It means, okay, any information that the police officer in the exercise of his judgment appears entitled to act in the particular circumstances of the case. So that's the definition of the word complaint and also the word credible information. For example, okay, let's have a look at the example here. The person who reported to the police, okay, is proved to be reliable. That's why it is reasonable or credible. Okay, here. For example, police informer or previously has led to arrest, okay, prosecution and conviction. So it cannot be information from any person here. It has to be somebody who is credible. Okay, so that's why it amounts to credible information. Okay, let's have a look at the decided case here. This is we have the case, all right, Abdul Rahman and Tan Jo Ho, 1968. So this is a appeal case, I believe. Okay, all right. Are suspected the appellant of carrying a concealed weapon upon his person in a coffee shop. Okay, so R invited respondent. R is respondent. Okay, respondent invited the appellant to the police station, but the appellant refused. Okay, so because of that, respondent dragged the appellant to the police station about 100 yards away. It's not that a long distance. Okay, all right. So and then the police recovered a knife from the fold of his sarong. So obviously, appellant was wearing certain sarong here, and there's a knife actually in the fold of the sarong. So the court held that the detention to conduct the force was not forced imprisonment. So whatever the police did here, actually, okay, respondent did here was actually something which is reasonable. Okay, so it doesn't amount to forced imprisonment. Okay, we have another case, Sha'ban, okay, and others, and Chong Fu Kam here. So the appellant, who was the appellant, the police constable, okay, he arrested the two respondents on suspicion that one of them was driving a lorry like recklessly and negligently. Okay, so what happened actually? A timber from the lorry hit the windscreen of a car, causing the death of one of the passengers. So it involves serious offense here. Okay, all right, it involves death. Okay, the court held that there was no reason to suspect the lorry was driven recklessly. So because of that, I mean, there's not enough evidence actually here. Okay, for the suspicion here. So because of that, the appellant was liable for false imprisonment. Okay, here, all right. Okay, and then it was also held that okay, it is unnecessary for the police to prove that there was prima facie proof of such offense. Okay, but a police can arrest if a reasonable suspicion existed of the plaintiff involvement in the offense here. So that's basically the rule that we extract from the case here. Okay, there must be proof. Okay. On the part of the police, all right, to prove that yes, they have reasonable suspicion. Okay, before the arrest could be made lah. All right. So, and then this is decision by Privy Council. Okay, this is what they said here. Okay, suspicion in its ordinary meaning is a state of conjecture, okay, or surmise where proof is lacking. Meaning that here, if you have suspicion, maybe there's no enough evidence. You just suspicion is there. Okay. For example, I suspect, but I cannot prove. Okay, so suspicion arises at or near the starting point of an investigation of which the obtaining of prima facie proof is the end. So it is the lower level, okay, before the proof is obtained. Okay. Now let's move further. Section 27, CPC, I mean the authority, the power given by citizen, okay, to make an arrest. So citizens, this is me. Okay, here it depends on the situation. Citizens may effect arrest if, in his view, the person has committed again a seizable offense. So if the offense is not seizable, then citizens cannot make an arrest here. Okay, and this is the actual provision, okay, for you to read here. Text 27, okay, we have subsection 1, 2, 3, and 4 here. Okay, all right. if there is no reason to believe that he has committed an offense, he shall not at once release here. So you can read further. Okay. Okay, what's the duty of the arrestor? Okay, so section 28 talk about that. So basically, once the arrest was being done, okay, penghulu or citizen shall, without unnecessary delay, take him to the police station. So after the arrest, what has to be done? Okay, so basically, this penghulu or citizen must take the arrested person to the police station, and from there is the duty of the police. Okay, all right. Police shall, without delay, take the arrested person to magistrate to decide what to do with him. So it's the power of the magistrate to decide further. And then police cannot detain for more than 24 hours. Remember we discussed especially without warrant. If there is warrant, then that's another story. So this is the case of without warrant, okay, for seizable offense. Okay, and this is the full provision. Okay, all the words here. Okay, I just reproduce it here. Okay, the procedure. And then the last one is section 117 CPC. It talk about the power given by to the magistrate. Okay, for example, if cannot complete investigation within 24 hours, okay, magistrate may authorize detention for a term not exceeding 15 days, okay, after the arrest was being made here. Okay, this is the procedure for your reading purpose. You can go through, okay, the procedure here. Actually, you're going to learn it in a greater detail when you do your criminal law and CPC later. Okay, let's move to the third defense, which is defenses of trespass to person, which is reasonable conditions. All right, so you can see the word reasonable and condition here. So it means that if there were reasonable circumstances, okay, in which the plaintiff was restrained, then it doesn't amount to false imprisonment. So it's very subjective. Okay, we have two cases here. We have the case of Robinson and Balmain and Hart and Wardale. Okay, for Robinson and Bellman Ferry Company Limited, very, very old case here. This is a common law case. So Robinson paid a penny, okay, to cross on a ferry. However, he narrowly missed the ferry and changed his mind about crossing. So he paid already, okay, he wanted to catch the ferry, but he missed it. So Robinson, okay, attempted to leave through the gate. He came through. However, it required another penny to be paid to leave, meaning that here he entered, he paid, and then he wanted to go out, all right? So he need to pay another penny, okay? But Robinson here, he refused to pay the penny because he had not crossed on the ferry. He said, no, I don't want to pay because I didn't use the ferry, okay? I didn't use the ferry service, so I don't want to pay. So Balmain New Ferry Company forcibly, okay, with force, prevented Robinson here from leaving until he paid the penny. No, you have to pay, otherwise you cannot leave. Okay, so the court held that there was no false imprisonment in preventing him. Okay, because why? The charge of for exit of 1 penny was reasonable. So after all, the whole area, it belonged to this Bellman Ferry Company Limited. Okay, you need to pay when you enter, and then if you want to go out, okay, you want to exit, you have to pay. All right, it doesn't matter whether you use the ferry or not. Okay, for the case of Hurt and Wardale Steel Company Limited, okay, this is the summary of the facts here. Partway through his shift, so he was working on a shift, okay, he's a miner, basically he was a miner. A miner demanded that he be taken to the surface. He wanted to go to the surface, okay, because it's below the shaft, I think. Okay, all right, the mining here, mining activities. So his request, the miner request, was refused. Okay, because of that, he sued for false imprisonment. Okay, House of Lords held that, well, the action failed because why? His employer were only obliged to transport him to the surface at the end of the shift. Okay, so if employer decided not to take him to the surface, so employer has all the rights to do so. Okay, all right. But actually, if you read further, okay, on the for contract law, okay, the miner could sue for breach of contract to bring him to the surface, but there was no such contractual duty. He could sue under breach of contract, but provided there was contractual duty on the part of the employer, but there's no such duty actually. So he failed, okay, for tort action, and if he were to sue for breach of contract also, he could fail as well. So this is reasonable condition on the part of the employer. There's no forced imprisonment. Okay, the fourth difference is about necessity. Actually, the content of the discussion will be similar to the one that we covered in the part one of the thoughts, law of thoughts. Okay, law of thoughts one. Remember we discussed about general defenses. Okay, for tortious action. So let's move next to the number 5, also more or less similar. Okay, we covered in the part 1 of our thought here. Okay, it's about self or private defense. So a person may use reasonable force, okay, to defend himself, his property, and those whom he is bound to protect. Okay, I think we discussed quite thoroughly. Okay, when we did our part 1 of law of thoughts. Okay. So for remedies, this is the last part. Okay, we are done with defenses. So for remedies here, so as usual, but then normally, okay, for tortious action, okay, we have this damages together with injunction as the usual remedy. But for false imprisonment, okay, we also have habeas corpus. Okay, what is habeas corpus here? It means okay, it is a writ okay, requiring a person under arrest to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. Usually, if the arrest was done unlawfully, so the person can ask for habeas corpus. And stuff like here, okay, it refers to individuals' implementation of their rights okay, without resorting to legal writ or consultation of higher authority. There's certain limitation for self-help here. Okay, we are done with our topic of trespass to person. Okay, starting with assault, okay, battery, and then we talk about false imprisonment, and then we discuss about defenses, and we end with remedies. So that's all for the topic trespass to person. So until the next topic, thanks a lot for listening. So stop share. Okay. Okay. Assalamualaikum warahmatullahi wabarakatuh.